RPR test is going to be the first one. 225, two boys for 5 minutes. RPR 225, two boys for 5 minutes. Ready? Would you state your full name for the record, please? Deborah Dean Owen. How old are you at the present time? Just celebrated my 18th birthday last week. Would you give us your present address? My husband and I live now at 2909 East 10th Street. When did you and Mr. Owen get married? On October 21, 1972. At the time of this accident, which was on March 22, 1972, you were not married? No, sir, I was not. With whom were you living then? My father and mother. With respect to the automobile that you were driving on the day of the accident, what make of automobile was that? It was a Chevrolet 68 Caprice. Who was the registered owner of that vehicle? My father, Floyd Dean. How many cars or automobiles did you have for your father at that time? Just one car and one truck. What vehicle did your father operate at that time? He drove the truck and my mother had the car. Did you have permission to drive that vehicle on March 22, 1972? Yes, sir, I did. Where were you going and where had you been? I had been to a furniture store on James Boulevard and I was going to Lane's on Rogers Road. For whose benefit were you going? Myself, I was getting married and I was looking at furniture. You were driving this car on this day with your father's permission and with his knowledge, with my mother's permission and with her knowledge. Did you have indirect permission of your father to operate the car on this day? He didn't know I was going to use it that day. Did you have a standing right to use the automobile? Yes, sir. For purposes of yourself and for your mother? That's right. At that time, how old were you? I was 17 then. How long had you been driving? Not quite a year because I had just turned 16 in October. How long had your father had that particular automobile? About 3 or 4 years, something like that. During that 3 or 4 year period, who maintained the car? My father took care of having it oiled and greased, things like that. And did you have any problems with this particular car? Yes, sir, the brakes. When did you have problems with the brakes? I guess about a week or two before. What, if anything, was done with respect to the braking system on the car? The brakes were checked and they were fixed. Now, were you familiar with the intersection of 5th Street and Charles Avenue where this accident took place? Yes, sir, I had been on that street before. How frequently did you travel it? Not very often, just on a date or something. In what direction were you going just immediately prior to this accident in question? I was going east, I believe. I don't know for sure. Which direction was Mr. Gordon operating his vehicle just immediately prior to the accident? He was going toward Drake Avenue. Did you stop at the stop sign where there was an intersection? No, sir, I did not. At what point in the intersection or prior to the intersection did you first see Mr. Gordon's automobile? It was before I got to the stop sign. Where was he at the time that you first saw him? He had just pulled out from the stop sign. Had you seen him in a stopped position? No, sir. What speed would you say he was traveling at that particular time as he pulled out? About 10 miles, I would say. What speed were you traveling as you approached the stop sign? I think I was going about 25. How far from the intersection were you when you first saw Mr. Gordon's car pulling into the intersection? A block or two would be my estimation. I am not real sure. What point in the intersection did the two cars come together? Right in the center. But what part of your car struck what part of his automobile? The front of my car hit his left back door. And did you apply your brakes prior to getting to the intersection? I did, yes, sir. Would you describe to me what took place when you applied the brakes? They went completely to the floorboard. Is it your testimony that you had no braking system on the car at all at that time? I did not see any braking system at all. With reference specifically to the pedal, you had no brakes at all when you pushed the pedal down. That was my big problem. Then you were not able to slow your vehicle at all. It was impossible to slow it down. Had you driven the car earlier on this same day? I did not. Had you driven it, say, during the week before this accident happened? Yes, sir. I believe I went to the grocery store. Did you experience any problem with the braking system at that time? It seemed to be working perfectly. If I understand what you have said, you had driven this car after the brakes were worked on since we got it back? Yes. And you noticed nothing wrong with the braking system at all? No, sir, did not. Did you remain at the scene and discuss this with the investigating officer there? Yes, sir, I did. Did you advise the officer there that your braking system had gone out? Yes, sir, I did. Did you examine the braking system of the car? He did. But what did he say with respect to that? He got in the car, tried the brakes, and they, of course, worked then. Had you made any stops prior to arriving at this intersection or just prior to the impact with Mr. Gordon's car? Yes, sir, there had been a red light and I had slowed up. When I got there, I turned and did not have to apply my brakes because the light changed to green. Did you apply your brakes as you approached the light? No, sir, I just drove up. I was going slow and all I did was take my foot off the gas pedal. Had you had occasion to stop your car between your home and the furniture store you went to? Yes, sir, there were several lights on James Boulevard. Had you stopped your vehicle at those lights? Yes, sir. And the brakes worked? They did. Did you have a conversation with Mr. Gordon following the impact between your vehicle and his vehicle? We talked some, yes, sir. This is a RPR jury charge, 200 for 5 minutes.
It's on the tape. It's on the tape. So it's played through like a boom box.
200 jury charge RPR. Ladies and gentlemen of the jury, in a civil lawsuit of this kind, the plaintiffs contend that they are entitled to recover damages of the defendant. In order to be entitled to recover, the plaintiffs are required to prove their charges, and it is therefore said that the burden of proof is upon the plaintiffs. There may also be a burden of proof upon the defendant to the extent that the defendant raises any affirmative defenses, such as charging the plaintiffs with having committed fraud or false swearing, or such as charging the plaintiffs with having brought the lawsuit in bad faith. As I say, the defendant would have the burden of proof upon those affirmative defenses, but upon all other issues, the plaintiffs would have the burden of proof. What does it mean to say that a party has the burden of proof? Where the burden of proof rests upon a particular party, it just means that that party must prove their claim by a preponderance of the evidence before they would be entitled to recover, or before they would be entitled to a verdict upon any issue upon which they have the burden of proof. Let me explain what we mean when we say that they must carry the burden of proof by a preponderance of the evidence. A preponderance of the evidence means merely the greater weight of the evidence, which is not necessarily determined by the greater number of witnesses upon the one side or the other of any particular issue, but rather by such things as the character of the witnesses, the intelligence of the witnesses, their means of knowledge, their interest or lack of interest in the outcome of the lawsuit. As I say, you will want to look to all of these matters as you determine where the preponderance of the evidence may lie with respect to any issue that will be for your decision. If the party having the burden of proof upon any issue carries that burden by a preponderance of the evidence, however slight that preponderance may be, then that party has done all that is required of him to be entitled to a verdict upon the issue upon which he has carried the burden of proof. On the other hand, if the preponderance of evidence favors the party that does not have the burden of proof upon a particular issue, then the party having the burden of proof has failed to carry the burden, and the opposing party would be entitled to a verdict upon that issue. Likewise, if the evidence is evenly balanced as between the parties upon any particular issue, then it means that the party having the burden of proof on that issue has failed to carry that burden, and the opposing party would be entitled to a verdict upon any such issue. The jury will, of course, be the sole and exclusive judges of the facts in this lawsuit, and the weight and credibility which you think should be given to the testimony of the respective witnesses. If you find that there is a conflict in the evidence, do not come to the conclusion that a witness has sworn falsely, but rather you should consider all of the evidence and make a determination as to which party is being the more credible and which party or witness you think the greater weight should be given to. You should carefully examine all of the testimony given, the circumstances under which each witness may have testified, and every matter in evidence that tends to indicate whether a witness is or is not worthy of belief. You should consider all matters which would be helpful to you in making a determination as to the weight and credibility that you think should be given to the testimony of the respective witnesses. In this lawsuit, there have been certain witnesses who have been testified and have stated opinions about certain matters in the case. Ordinarily, a witness is not permitted to express an opinion. It is for the jury to make their own mind up as to the conclusions and opinions that should be drawn on the basis of the testimony that is presented in the case. This is an action upon an insurance policy. The rights and the liabilities of parties to a written contract are expressly spelled out in that contract. Insurance is simply one form of contract, and generally it is no exception to the rule that one must look to the written insurance agreement itself in determining the rights and the liabilities of the parties to that insurance agreement. The parties under a contract are usually entitled to no more and obligated to no less than is provided in the contract itself. The mere description of the contract as an insurance contract does not tell you much of anything about that except as you read the specific provisions of the contract itself. As I said, the mere designation of a contract as an insurance contract does not of itself entitle a party to any rights, nor does it impose any obligation upon either party, but rather you must look to the specific language of the contract and determine the extent of the rights of any party claiming rights under the contract, or the extent of the obligations of any party whom it is contended is obligated under the contract. In interpreting the specific language of the contract, you will give the words their ordinary meaning and construction unless the court should specifically instruct you otherwise in regard to any specific word, or if there is any particular word having any special meaning. You are instructed that one who enters into a written contract of insurance is presumed to know the contents of that policy and would be bound by the conditions of the policy. Accordingly, I want to call your attention to certain of the specific provisions of the insurance policy. RPR 180 lit. Ready? Mr. President, last year Congress appropriated a sum in excess of $323 million for capital outlay projects for the city of Washington. As a result, in conference last year, the House and Senate conference agreed that henceforth a ceiling should be established for capital outlays and projects of $150 million per year. Why? The reason is simple. 10 years ago, the debt service cost of the city, the cost of interest payments and principal payments was less than $2 million. Today, as a result of the borrowing power we have extended to the city, the debt service cost, which is primarily in interest payments, exceeds $28 million. Now, the committee felt that if the city were permitted to continue with this capital project, no one would know what the capital debt service cost would be, say 20 years from now. We estimated that if we maintain a ceiling of $150 million a year, the debt service cost in the year 1989, which is not too far away, would be $203 million per year. In other words, it is easy for city officials to go out to their people and tell them that they have got this and that project because they do not have to pay for it today. Someone's son and daughter will have to pick up the tab for it 15 or 20 years from now. It should also be noted that Congress, in response to the pleas of city officials, appropriated large sums of money for capital projects. At this moment, we have over $300 million worth of approved projects still available for construction purposes. If these projects were of such high priority when they were presented to us a year ago, 2 years ago, or 3 years ago, why have the funds not been used? I have suggested that the money on hand for these projects be reprogrammed and used for the jail. In order to be consistent with my views that the people of the District of Columbia deserve self-government, I have tried my best to rely on the direction which has been coming from the mayor's office. The subcommittee therefore requested the city to submit to this committee of ours a priority list of their projects. In that event, we limited the construction program to $82 million. What would their priorities be? And Mr. President, in that list, they did not include the city jail. Now, the jail was listed in a third group behind at least 22 other projects. I agree with my distinguished colleague from Illinois that the jail is important. I was at the hearing and listened to the testimony. I was personally rather surprised to find the city coming forth and not including the jail as a high priority matter. I feel that the jail should be constructed. It should have been constructed 5 years ago. However, I am still bound by this priority list. Therefore, I have discussed it with their fiscal officers and have suggested that they come forth with a new program of requests to set aside some of these non-priority matters that have been pending for years and propose a start of construction on the jail. Incidentally, it might be well if the Congress were to take a good look at the construction plans for the jail. I have made a study and I find that less than 25% of the residents of the District of Columbia live in air-conditioned homes. This jail will have central air conditioning. And maybe this is the way to treat our felons. However, I would think that our people get air conditioning before the prisoners. I realize that the cuts proposed by the Senate subcommittee are rather harsh. Somewhere along the line, someone must apply the brakes to stop spending. And since I have committed myself to home rule, and since I have assured the city that I will try my best to go according to their direction, we placed their priority list in the committee report with only a few minor revisions. I have tried my best, although this job is not my idea of a pleasant assignment, because I am a firm believer in home rule, but I have tried my best to do my job. The state I represent has been struggling for home rule for a long time. We got it 13 years ago. I would like to see Washington get it tomorrow. As long as we do not have home rule here, I will try my best to provide some fiscal responsibility. I hate to see the young children of today pick up the tab for some of the luxuries that are not necessary. Mr. President, I could go on and on for hours if the senator wants me to, and I could tell him some of the items that have been requested in the capital outlay budget. Items that personally I see as being unnecessary items, that they could be set aside for a few years at the least. In closing, I would like to note that throughout the United States, our people have experienced hard times. Now, this Congress has been, in my view, very generous to the people of this city. I would like to temper our generosity with some responsibility. Okay, this is a 225, two-voice, RPR, 5 minutes. Ready? Will you state your name and address, please? Edna Wells, 54 Howard Street, Boston, Massachusetts. Would you give us your date of birth, please? October 20, 1897. What is your occupation? I have none. With whom did you make your home? I am all by myself. Is it a single home that you occupy? No, I am in a duplex house. And how many rooms do you occupy? 6. You occupy that by yourself? Yes. Do you own the other half too? Yes, I own the whole house. Do you have a maid of any kind? No, I do not. No help at all? No. Do you have any usual activities? Are you a member of any associations or clubs or anything of that kind? Yes, I have several. I am on a visiting committee from the church and also take an active part in that. Do you own any other real estate? No. Do you drive a car? Yes. Who is your family doctor? Dr. Jones. For how long has he been your family doctor? 20 years. Now, had you done any traveling of any nature prior to the time you went on the board, the President Jackson? Yes. I have had a trip to Europe. By sea? Yes. What ship did you go on? Well, the ship I went over on is one I don't even remember the name of. It is so long ago. It was a Greek ship. Was this a long time ago? 10 years ago, I came back on the Queen Mary. Where did you first go on board the President Jackson? In New Jersey. And you had taken passage for a trip to where? Around the world, back to New Jersey. Now, did you make this trip with anyone? No, alone. How long beforehand had you made the arrangements? Well, I think I started in November or December of the previous year, trying to get arrangements to see what was possible. Did you have a room to yourself there, or did you have someone who shared your room? No, I had a single room. For how long were you on the vessel altogether? Of course, there were trips on land. I mean, over what elapsed period of time? About 3 months, I would say, a little more. How long were you on the vessel before you were hurt? That is, from what date to what date? Well, it all happened on the 26th of May, just that one day. We had got off the ship and got back on, so it was just that one day. What was the date that you first went on the vessel at New Jersey? I think it was either the 26th or the 28th of February. I am not sure. And where did the vessel go first? Did it cross the Atlantic? No. I went through the Panama Canal. To the Pacific? Yes. To the West Coast. Had you gone ashore with someone else in Naples? Yes. Who was that? Miss Butler. And is she someone you had come to know during the voyage? Yes. Was she a young woman or more about your age, a little bit younger than I was? Do you know what her normal occupation was? She was retiring, or she had retired. At what time did you return to the vessel at Naples on May 16? I don't know the exact time, but it was in the late afternoon between 4:30 and 5:30, somewhere around there. Were you in company with Miss Butler? Yes. Was anyone else with you? No. What kind of pier was the vessel at there? Well, a regular cargo pier, I imagine. As you approached the gangway, did you notice anything different about it at that time, from the time you had gone ashore? No. Where was the platform that you referred to when you came back? It was evidently resting on the dock. Can you tell us from your observation? I didn't look, just stepped on it. You did look at it when you stepped on it, as you would any place that you are walking on, but I didn't give it any special observation. But from your best recollection, it appeared to be resting on the pier. It appeared to be resting there. Where was the distance between the platform and the edge of the pier itself towards the water? I really didn't notice. Was anyone else with you besides Miss Butler? No, not at the time. And how was the weather? Beautiful day. It was still daylight? Yes. Had you had any particular orders as to when you were due back on the ship or when you were to return? No. What time was the evening meal? Usually around 6:30. Now, as you approached the gangway, what activities were taking place on the vessel? I assume they were moving cargo. You don't remember whether they were discharging or loading? No, because there was both going on. You don't remember whether there was any cargo activity or not specifically? I didn't notice anything special, but there were a lot of men working around there. So they evidently were doing something, taking on cargo and taking off cargo. As you approached the gangway, who went first? Miss Butler. Were you carrying anything? Yes. What were you carrying? I was carrying a basket, a basket. Were you also carrying a handbag? No, I had everything in the basket. But what was the size of the basket you were carrying? About like that, I should say. Probably 12 by 10 or something. About that big and deep. A combination handbag and basket. What did you have in the basket, just generally? Purchases I had made. Were you talking with Miss Butler as you went up the gangway? I don't recall. Did the gangway have sides? Yes, rope sides. Were you holding on the ropes as you went up the gangway? I started to hold on. I grabbed it with my right hand. Are you right-handed or left-handed? I'm right-handed. When you say you started to hold on, tell us what you mean by that. I started up the gangway, and at that time the platform had gone off, so it tossed me around, and I got hold of the platform rail and held on that. What was the size of the platform? It's hard to say. Do you want it in feet? All right. I would say it was probably the width of this table. Can you give us in feet? Because it has got to appear in the record. Was it square or was it round? Okay, this is 180 lit. RPR 180 lit. Ready? Ladies and gentlemen, I have requested this meeting as a result of the series of articles that have appeared growing out of my press conference last Thursday. I am speaking to you without any written notes, and my remarks are being made on the basis of my best recollection of events. Last Thursday, a number of you commented on the fact that I seemed to be irritated and a little angered. All those words are correct. After 5 weeks in the Middle East, I was not thinking about the various investigations going on in the United States. I did not prepare myself for the press conference by reading the records of investigations that I believed had been completed. I have testified before the Senate Foreign Relations Committee in public session and in executive session. And then at a closed meeting with this committee, we went over each FBI report on the wiretaps that existed. Since the press conference of last Thursday, there have been many articles and several editorials published. I was prevented by the short time interval between that date and the President's departure to hold a press conference in the United States before we left. However, I did send a letter to the chairman of that committee, and since sending the letter, there have been many more articles, and many are undoubtedly in the process of being written. In these circumstances, it is not appropriate for me as Secretary of State to go with the President to the Middle East without having a full discussion of the facts as I know them, keeping in mind only that I do not have all my records here with me. I shall now discuss these facts with you. I shall afterwards stay for as long as there are any questions. There will be no ending of the question period as long as there are any questions left to be asked. First, what is it we are talking about? The impression has been created that I am trying to hide something with misleading testimony. The fact of the matter is that the wiretaps in question were legal. They followed established procedures. When they were begun, the then Attorney General and the then Director of the FBI assured me that they were restarting procedures that were carried out in previous administrations. Before public reputations are attacked or destroyed, elementary fairness requires that this particular statement be looked into and that it be made clear whether the national security wiretaps were in fact carried out in previous administrations. The history of these wiretaps started from a series of leaks that occurred in the spring of 1969. As Assistant to the President for National Security Affairs, I had the duty to call the attention of the President to what seemed to me violations of national security. These violations cannot be assessed only by analyzing the merit of individual documents, but they must also be analyzed in terms of the confidence other governments can have in a government that seems totally incapable of protecting its secrets. After a series of open violations, the President ordered, on the advice of the Attorney General and the Director of the FBI, the starting of a system of national security wiretaps. I repeat, I was informed when I was told about this that it was the restarting of a system that had existed in previous administrations, even though it may have been supervised from different offices. I was asked to have my staff supply names in 3 categories: individuals who had adverse information in their security files, individuals who had access to information that had leaked, and individuals whose names appeared as a result of the investigation that submission of the previous 2 lists might entail. My office, for which I bear full responsibility, submitted those names in carrying out this program. I would be prepared to let any proper investigation body examine the list to make certain that no name was submitted through my office that did not fit into one of these categories. In submitting these names, we knew that an investigation was certain and that a wiretap was probable. I so testified in the executive session of the Senate Foreign Relations Committee, no matter how sentences are now taken out of context. The basic issue now is whether through my office or with my knowledge any names were submitted for any purpose other than the protection of national security, and whether the information was used for any other purpose. When a wiretap was installed, the FBI would send a report to my office only when, in their judgment, the conversation involved violations of national security. It is totally incorrect and outrageous to say that these taps that were submitted to my office involved a description of extramarital affairs or pornographic descriptions. The system that was followed in the operation of the national security wiretaps was, first of all, that no verbatim transcript was ever sent to my office. What was sent to my office was a 1.5-page summary of conversations that seemed, in the judgment of the FBI, to involve issues of national security. These memoranda were then screened in my office, and if, in the judgment of those who had this responsibility, were of sufficient importance, they were shown to me. Okay, this is jury charge 200, jury charge RPR. 5 minutes. Ready? Ladies and gentlemen of the jury, the plaintiff's cause of action is stated in the complaint which was read to you at the beginning of the trial. To this complaint, the defendant has filed an answer denying the allegation of negligence charged against him in the complaint and denying every proposition of fact that is required to make out a case of liability against him. Before there can be a recovery in this case in favor of this plaintiff or any plaintiff in any case, the law imposes upon him or her the duty to prove by a preponderance of all or any evidence that the defendant was guilty of any negligence in one or more of the acts of negligence charged against him in the complaint. The burden is also upon the plaintiff to prove that said acts of negligence were the proximate cause of the collision in